on to the next section of the rules, specifically conflicts of interest. I would like to point out that this section of the rules is the most highly tested portion of the rules. It makes up 12 to 18% of your total exam. The reason I stress this is because this area of the rules should be your absolute first priority if you're trying to maximize your chances of success on this exam. While you should never ignore any portion of the rules, it's very helpful if you remember how important each are with respect to the total number of questions you'll see on your exam. Thus, this area of the rules should be your number one priority. So much like the other sections, I'm not going to cover every single rule, but instead, we'll cover those that we've received lots of questions on in the past or those that we've seen tested in rather tricky ways. So the first rule that I want to talk about is current client conflicts. The rule states a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists in two scenarios. The first scenario is if the representation of one client will be directly adverse to another. For example, this could be as straightforward as representing a plaintiff and a defendant in a matter. A lawyer can't do that, since the interests of those clients are directly adverse. Let's look at some of the examples in the outline. The first example says, if a lawyer asked to represent the seller of a business in negotiations with the buyer, who's represented by the lawyer, not in the same transaction, but in another, unrelated matter, the lawyer should not undertake the representation without the informed consent of each client. Why? Because while it's not the exact same matter, like in my first example, the interests of these clients are directly adverse, and therefore it would create a current client conflict. Similarly, though, on the other hand, simultaneous representation in an unrelated matter of clients whose interests are only economically adverse, such as the representation of competing economic enterprises in unrelated litigation, does not ordinarily constitute a conflict of interest and may not require consent of the respective parties. It's not uncommon for a law firm to represent a certain type of client, and those clients could be in competition with one another. That doesn't automatically mean there is a conflict of interest. To give one more example not in the outline, a lawyer regularly represents an airline with respect to personal injury lawsuits. And one of the airline's employees approaches the lawyer and asks the lawyer to represent her in a wrongful termination lawsuit against the airline. Can the lawyer do this? And the answer is no. This instance is a classic example of the parties having directly adverse interests, and therefore a current client conflict exists. So while it's not the same matter, one lawsuit would be a wrongful termination lawsuit and the other a personal injury lawsuit, it doesn't matter. In one lawsuit, the lawyer is going to be representing the airline. And then in the other lawsuit, the lawyer would be suing the airline. That amounts to a rule violation. Now, getting back to our rule, we said that current client conflicts exist in two scenarios. The second part of the rule states a lawyer shall not represent a client if the representation involves a concurrent client conflict. A concurrent client conflict exists if there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibility to another client, a former client, a third person, or by the personal interests of the lawyer. Turning to our examples. A lawyer asked to represent several individuals to form a joint venture is likely to be materially limited in the lawyer's ability to recommend or advocate for all possible positions that each might take because of the lawyer's duty of loyalty to all of them. The conflict, in effect, forecloses alternatives that would have otherwise been available to the client. To pause here for a second, because all of these individuals hired the lawyer in a joint enterprise, this duty of loyalty that the lawyer owes them runs to all of them equally. So the lawyer can't give advice to each individual person. That might not be in the best interest of the other client, because the lawyer's duty of loyalty runs to all of them together. This means this lawyer wouldn't be able to fully advise each of them on everything. The next example is a great illustration of a lawyer's own personal interest creating a conflict. It says, When a lawyer has discussions concerning possible employment with an opponent of the lawyer's client or with a law firm representing the opponent, such discussions could materially limit the lawyer's representation of a client. I think this makes sense because if you're being represented by a lawyer who's in talks with the opposing party's law firm for an employment opportunity, you should very much question your lawyer's loyalty. Is it to you or his or her ability to get a job? The rule continues. If there is a current client conflict, a lawyer may represent a client if the following requirements are met. The first is the lawyer has to reasonably believe that they'll be able to provide competent and diligent representation to all affected parties. 2, the representation cannot be prohibited by law. 3, the representation does not involve an assertion of a claim by one client against another client represented by that lawyer in the exact same litigation or in other proceedings before a court. And 4, each affected client gives their informed consent confirmed in writing. So the big takeaway from this rule is the only way around these current client conflicts is to satisfy all 4 of these requirements and get each affected client to give their consent in writing. When you review these rules, keep in mind who must consent and if it must be in writing. These points make excellent MPRE questions. Before we move on, a few things to note. Some states prohibit lawyers from representing 2 defendants in a capital case. In these types of cases, this type of representation will be prohibited by law. Thus, the lawyer can't represent both defendants, even if they would have otherwise agreed, because the rule above says it cannot be prohibited by law. Turning to another example, a lawyer represents a husband in a business matter where the lawyer obtains confidential information regarding his finances. While the husband's business matter is pending, the wife wants the lawyer to represent her in a divorce action against this man. The lawyer cannot represent the wife. This is an unconsentable conflict where the lawyer can only take on the representation of just the husband, even if the husband were to consent to the representation of the wife. Why? Because these clients' interests would be directly adverse, not in the same litigation, but in other proceedings in front of a court, which is in direct conflict with one of the rules requirements. Let's move on to the rule regarding former clients. The rule says a lawyer who has formerly represented a client in a matter shall not thereafter represent another person in that same or a substantially related matter in which the person's interests are materially adverse to the interests of the former client, unless the former client gives their informed consent confirmed in writing. In understanding this rule, one must be familiar with certain vocabulary. Specifically, be familiar with the definition of substantially related. This means matters are substantially related if they involve the same transaction or legal dispute, or if there is otherwise substantial risk that confidential, factual information that would normally have been obtained in the prior representation would materially advance the client's position in the subsequent matter. If you learn information about your client, and then later you could use that information against your client to help a new client, then you know matters are substantially related, and that is a conflict of interest under the rules. To better understand what this rule means, let's turn to the examples in the outline. The first example says, a lawyer could not properly seek to rescind on behalf of the new client a contract drafted on behalf of the former client. This example is a great illustration of the same matter. If I draft a contract for you, and then you pay me and you go on your way, and then some other person comes to me and asks me to represent them in trying to get out of that contract that I drafted, well, your interests are adverse, and it's the exact same matter. Therefore, I could only do that if you gave your consent. Next, a lawyer who's prosecuted an accused person could not properly represent the accused person in a subsequent civil action against the government concerning that same transaction. This example makes it clear that the lawyer is switching sides, first representing the government and then going after the government in the next. This is a conflict. 3, a lawyer who has represented multiple clients in a matter may not represent one of those clients against the others in a same or substantially related matter after a dispute arises amongst them, unless all of them give their informed consent. When a lawyer represents a group of people, you can think of these rules as treating them like they are one person. Thus, lawyers have to be careful that the client knows what they're getting themselves into. For instance, they can't claim privilege against each other. So if a dispute arises and one of the parties asks you to represent just one of them against the others in the group, you can't do that because the others in the group are technically your former clients. This means the others would have to provide their consent. Turning to the point of matters being substantially related, a few examples to illustrate the rule. A lawyer who's represented a business person and learned extensive financial information about that person cannot then represent that person's spouse in seeking a divorce. So, stopping there to reflect on this example. While a business transaction and a divorce are not the same matters, they are substantially related because the lawyer has confidential information that would be very helpful to the spouse in a divorce action of that business person. Next example, a lawyer who's previously represented a client in securing environmental permits to build a shopping center would be precluded from representing neighbors seeking to oppose the rezoning of the property on the basis of environmental considerations. However, the lawyer would not be precluded on the grounds of this substantial relationship from defending a tenant of the completed shopping center in resisting an eviction for non-payment of rent. The lawyer cannot switch sides regarding the environmental permit because this is the same matter. However, as it relates to the lease agreement, that is not the same matter, nor is it considered substantially related because there is no risk of shared confidential information. To give one more example about substantially related, it's not in your outline. A lawyer represented a woman in the purchase of a home. The home was in a neighborhood with a homeowners association. The woman pays her homeowners association dues every year on time for a few years, and then she loses her job. Due to having no income, the woman doesn't pay her dues. The homeowners association approaches the lawyer to represent them in placing a lien on this woman's property for non-payment of her dues. Can the lawyer represent the association in this matter? And the answer to this question is going to be no. While it's technically not the same transaction, the matters are substantially related because there is this risk of confidential information that the lawyer learns while representing the woman being relevant to advance the position of the homeowners association in the subsequent action. The next rule we will talk about is regarding clients of the lawyer's former firm. Starting with the rule, it says, a lawyer shall not knowingly represent a person in the same or a substantially related matter in which a firm with which the lawyer was formerly associated had previously represented a client whose interests are materially adverse to that person and about whom the lawyer has acquired protected information under their duty of confidentiality that's material to the matter, unless that former client gives their informed consent confirmed in writing. So to stop there, if a lawyer works at law firm A and then quits and gets hired at law firm B, and at law firm B, the lawyer then cannot represent the clients of law firm B if they have interests that are materially adverse to the clients that the lawyer represented while he worked at law firm A. Pursuant to the rule, the only way the lawyer could do this is if the lawyer got the informed consent from the clients at law firm A. The other thing to note about this rule is that lawyers who have general access to client files at a law firm and participate in discussions regarding law firm cases and their progress are inferred to have confidential information about those clients' cases. So if you encounter a fact pattern that explains a lawyer has access to client information, then the rules assume the lawyer has confidential information, which means this rule applies to them. This is true even if the lawyer in question does not actually have confidential information. Turning to our next set of rules about prospective client conflicts. To start, let's define who a prospective client is. This is someone who consults with a lawyer about the possibility of forming a client-lawyer relationship with respect to a matter. The rule states that even when no client relationship ensues, a lawyer who has learned information from a prospective client shall not use or reveal that information unless an exception to confidentiality applies. Further, a lawyer shall not represent a client with interests materially adverse to those of a prospective client in the same or substantially related matter. If the lawyer has received information from the prospective client that would be significantly harmful to them in the matter, except as provided by the rules. So let's stop there. Many law firms offer free consultations. So let's say you work at a law firm that does just this, and someone comes into your office and tells you some information about their case, but they don't end up hiring you. Well, this is unfortunate for a few reasons. Mainly because now, if the opposing party to this action came to you and wanted to hire you, you can't move forward with that representation because now you have information about that prospective client and you're not allowed to use it. The theory is the information that you gained from that prospective client would be significantly harmful if you were to share it or use it against them. So, therefore, you can't. Another thing to keep in mind about this rule is that many times these conflict of interest rules are imputed upon all of your other firm members. In other words, if one lawyer is disqualified, then the whole law firm is disqualified. Now, there are some exceptions. For instance, if you're disqualified for personal conflicts like religious reasons, or maybe there is a physical sexual relationship between parties, that's not imputed to other members of your firm. But generally, any other type of conflict would be. Thus, one lawyer's conflict of interest is generally the whole law firm's conflict of interest. So getting back to that prospective client conflict rule, how do we get around this conflict? Well, the first way we could get around it is getting consent from those affected parties. So this means both parties give their informed consent confirmed in writing. The second option is a screening option. Under this rule, screening requires that the lawyer who has this information took reasonable measures to avoid exposure to more disqualifying information than was reasonably necessary to determine whether to represent that prospective client or not. Additionally, the disqualified lawyer is timely screened from any participation in the matter, and he's not given a fee. And lastly, written notice is promptly provided to that prospective client. Therefore, the key takeaway is not just that we screened that disqualified lawyer off the matter and that we give notice about that screening procedure to the prospective client, but we need to make sure that when the lawyer meets with that prospective client, they got as little information as possible, meaning they took steps to make sure they didn't get too much information. The next rule in this section that I'd like to discuss is a different kind of conflict of interest. The rule states that prior to the conclusion of the representation of a client, a lawyer shall not make or negotiate an agreement, giving the lawyer literary or media rights to a portrayal or an account based in substantial part on information that relates to the representation. This means if a lawyer is representing a movie star, let's say they're going through a bitter divorce and it's highly publicized and it's being dragged out. If the movie star that lawyer is representing is running out of money, so that movie star makes an offer to the lawyer and they say, hey, I'm running out of money. Can I give you rights to writing a book about my divorce in lieu of me paying you? The lawyer can't agree to such an offer and can't even negotiate such a thing to take place after representation. The idea behind this rule and the prohibition on even negotiating such an agreement is that we want to make sure the lawyer is properly motivated. A lawyer should be motivated to represent their clients by doing what's in their best interests, not what's in the lawyer's best personal interests. And if a lawyer gains the rights to a book or a movie deal, the lawyer may want to do other things while representing them that might make a really good book or a good movie, even if that might not benefit the client. That's why we do not want any sort of negotiation or agreement occurring while the matter is ongoing. The next rule is about malpractice liability. The rule is unique, and I'll tell you why. It says that a lawyer shall not make an agreement prospectively limiting that lawyer's liability to a client for malpractice unless the client is independently represented in making that agreement. So let's stop there. This is the only place in all of the rules where your client must be independently represented to enter into one of these agreements. You're going to see throughout the other areas of the rules that we're supposed to encourage our clients to seek independent counsel or representation in entering into certain types of agreements. But ultimately, if the client does not want to hire an attorney in those other instances, then they don't have to. Here, however, the rule makes it clear that the only way you can ask your client to prospectively waive or limit malpractice is to be independently represented by another lawyer. So if the client refuses, or if they simply aren't represented by another lawyer in the making of this agreement, then you can't have them waive this right. Now compare that rule to the next. A lawyer shall not settle a claim or a potential claim for such liability with an unrepresented client or a former client, unless that person is advised in writing of the desirability of seeking advice of independent counsel and given a reasonable opportunity to get advice of independent counsel and connection therein. So, you can see that this is a great example of where you're supposed to encourage your client or former client to go get outside independent counsel. And in fact, you're supposed to make that type of recommendation in writing. But ultimately, if they choose not to hire someone and they just want to settle this claim with you, they can. And you would not be in trouble for entering into such a settlement agreement after you've made this recommendation. The next two rules that I want to talk about are about a lawyer going from governmental work to private practice and those conflict of interest rules that apply. Then we're going to talk about the reverse, someone going from private practice to work for the government. So first, we will talk about government to private. The rule says, except as the law may otherwise expressly permit, a lawyer who has formerly served as a public officer or employee of the government is subject to the former client conflict rules. So to stop there, we've already covered that rule. Moving on. 2, they may not otherwise represent a client in connection with the matter, in which the lawyer participated personally and substantially as a public officer or employee, unless the appropriate government agency gives their informed consent confirmed in writing to that representation. So stopping there. Remember, always pay attention to who must give their informed consent confirmed in writing. Here, it's the government. You can think of this as the former client giving their informed consent. The other thing I want to point out about this rule is that there's some new vocabulary being used that you need to understand. The first word is matter. For purposes of this rule, it is interpreted narrowly, and it means a specific set of facts involving a specific set of parties. Let's look at the example in the outline. A lawyer who worked on regulations for an agency when she worked for the government was asked when she moved into private practice to argue that the regulations were not properly applied to a specific party. The lawyer can represent that party because drafting regulations is not a matter, because it does not involve specific facts or specific parties. Now, the phrase you need to be able to define is personally and substantially. This means that the lawyer in question was actually personally involved in the matter. They didn't just rubber stamp something or generally oversee something. So to give you a quick example, let's say a lawyer was the senior attorney in the county and she rubber stamped her signature on every case that came through the county. This lawyer would not be considered to be personally and substantially involved in every single case that she rubber stamped. She's only involved in those in which she truly participated in. And from a common sense perspective, I think this does make a lot of sense, because you would be conflicted out of so many cases if it were defined in a more expansive way. Additionally, as it relates to this rule, it states that imputed disqualification is applicable here as well. It states that when a lawyer is disqualified from representation, no lawyer in their firm for which they're associated with may knowingly undertake or continue representation in such a matter, unless the disqualified lawyer is timely screened from participation in it and is given no fee, and written notice is promptly given to the government agency to enable it to ascertain compliance with this rule. So in other words, if you're disqualified, your whole firm is disqualified. Remember, one lawyer's conflict of interest is generally the whole law firm's conflict of interest. Now, let's turn to the other part of this rule. If you're transitioning from private work to working for the government, what do the rules say here? The rule states that except as the law may otherwise expressly permit, A lawyer currently serving as a public officer or employee is subject to the present client conflict rules, which we've already discussed, and the former client conflict rules. Again, we've already discussed those too. And they may not participate in a matter in which they participated personally and substantially while they were in private practice or non governmental work, unless the appropriate governmental agency gives their informed consent confirmed in writing. So I'm going to stop there. Here you can see that this rule utilizes the words personally and substantially again, which we've already defined. Second of all, I said always pay attention to who has to give their informed consent. The good news regarding these last two conflict of interest rules regarding government to private work or private to government work. No matter what rule you're looking at between these two, the government is the party giving their informed consent confirmed in writing. So turning to the example on this point in the outline, a lawyer did zoning ordinance work in private practice for a company where he challenged the zoning ordinances. The lawyer then leaves private practice to work in the public sector for the government, where he rewrites zoning ordinances that he used to challenge. While working for the government, the lawyer would need informed consent in writing from the governmental agency where he was working due to the nature of his previous work in the private sector. Turning to the next part of this rule, it states that a lawyer currently serving as a public officer or employee may not negotiate for private employment with any person who's involved as a party or as a lawyer for a party in a matter in which you're participating personally and substantially. Now, the one exception is for lawyers who are law clerks working for a judge or another type of adjudicative officer, or if you're an arbitrator. These lawyers are allowed to negotiate for private employment as the rules would otherwise allow. So that wraps up our conflict of interest rules that we're going to be talking about together. Remember, this portion of the rules is the most highly tested. What we would recommend you do is not only read through the rules and, of course, try to memorize them, but if you're a visual learner, focus on the chart provided too. It's a great way to see the rule, how it gets broken down, and if there's any way around it.